incident. And since the court has already excluded it as part of the state's case, I believe it's only fair that it be excluded as part of the defense case.
Thank you. Mr. Sharafsky.
Judge, I would never relitigate a motion that I've won. So I understand, having been a lawyer for a little bit, that if I open a door or I do something that would potentially bring something up that the court has already precluded, I guess I do that at my own risk. That's not the goal. I would never do that. It makes no sense based on what Mr. Binger has told you today that I would ever try to do that. But she is a witness. She was present during the incident. So if we believe, I've never had this before, where we believe that she may have relevant information as somebody that was present at the scene, that she be preemptory barred from testifying because they think that we're opening a door that I have no intention of opening. So I think it's only reasonable that the court allow her to testify if she has relevant information.
Yeah, real quick. I don't mean to cut off Sharifsi. He's 100% right. Like, this is an attenuated event. She's not coming to testify about that. And why would we be asking about that? She was there the day of the incident. She's a literal witness to the incident. Why would we preemptively bar her from speaking when she could have evidence, she could have facts or testimony that is probative to the incident? The June incident is not probative to what happened on the night that Kyle Rittenhouse cleaned up the streets of Kenosha. It's just not relevant. It has no legal relevance. It doesn't go to his state of mind. It doesn't go to his understanding of self-defense or whatever other bullshit Binger's trying to bring up so that he has an excuse to bring up a prior bad act, which would be excluded by the rules of evidence. What it does have, though, is a person who is witness to the defendant on the date of the incident. Now, if she saw him in the morning and then this is later, blocks away, and she wasn't there at all, I don't know. I don't know the extent of it, but she is, I mean, we're talking about a proximity in time and place that is far different from the June incident. It has nothing to do with what's going on. And if you notice, if you want to know the weakness of Binger's argument here, it's really simple. Well, they got what they wanted, so it's only fair, he said. I know you guys caught that because, when someone says only fair, well, it's only fair. You know that kid, right? You know the kid who says, well, it's only fair if this happens. Yeah, sorry. It's not about fairness here. It's about what the rules of evidence are and what the laws are and what the rights of the defendant are. It's not about fair, and certainly not fair for the prosecution. If nothing else, the prosecution deserves unfairness. So that's what's going on. You can always look for weasel words and weasel arguments in prosecutor statements. First of all, you've caught me on a day when I'm particularly unamenable to prosecutors. But second of all, Binger has these tells all over the place. Well, it's only fair. Sorry, you don't get fair. You're a prosecutor. Your life is already, you're lawyering on easy mode. You don't deal with any of the shit that lawyers deal with, and you have the entire weight and resources of the state behind you, and you will be paid by the government no matter what you do. You don't have to deal with any of the complications of being an attorney. You don't have to collect money. You don't have to bill a client. You don't have to do any of that because you're salaried by a government with resources that are at your disposal, especially in a high-profile case like this.